Hello, this is Nick Kyriacou, and this is the mini summary for the week of April 19th. So, like last week, we were given a bunch of Supreme Court cases, and these cases generally followed three topics. The first of which was affirmative action, voting rights, and then same-sex marriage. And I'm just going to pick a Supreme Court case from each and briefly discuss it. So, the first of these cases was Grutter versus Bollinger, and in this case, what essentially happened was there was a law student, a highly qualified white female named Barbara Grutter. She applied to the University of Michigan Law School, and she was denied. The law school admitted that it uses race as kind of a factor in its decision-making, so she sued on the basis that they were discriminating against her because of her race. And then the question at heart was, does the University of Michigan's law school use of racial preferences violate the Equal Protection Clause of the 14th Amendment? And in a 5-4 decision, the answer was no, on the grounds that the law school is working towards making a more diverse student body, and that race is not an exclusive factor, so no application alone is going to be determined on the basis of race. The second of these decisions was Shelby County versus Holder, and what you can see is this, as we read closer, this really becomes a matter of states' rights versus federal rights. So what the case is decided over is a town in Alabama called Shelby County sued the federal government on the grounds that it was violating it was too far infringing upon their state's rights. So what happened was the Civil Rights Act of 1965 was mainly designed at targeting discriminatory voting practices. So what it did was it instituted a lot of strict federal scrutiny of regions with high voter discrimination. So the question at heart was, does a certain segment of this Voting Rights Act exceed congressional authority under the 14th and 15th Amendment, and therefore violate the 10th Amendment and Article 4 of the Constitution? And in a 5-4 decision, the basis was yes, it does. On the basis that voter discrimination rarely occurs now, the federal government and Congress cannot exceed too much on the states' rights, and states must be allowed to have self-government. The final decision was Aubergeville versus Hodges, and this is about same-sex marriage. So essentially what happened was many groups of same-sex couples from Kentucky, Ohio, Michigan, and Tennessee, they all sued their respective states on the grounds that they failed to recognize / issue them marriage licenses. So two questions came to be. The one was, does the 14th Amendment require a state to license a marriage between two people of the same sex? And the second was, does the 14th Amendment require states to recognize marriages licensed legally, same-sex marriages licensed legally from other states? And the answer to both these questions was yes. This was done on the basis that that marriage is a fundamental cornerstone of society, and that it must be protected at all costs. Does the use of racial preferences violate the Equal Protection Clause? And at least in Grutter versus Bollinger, the Supreme Court decided in a 5-4 decision that it does, society, and that it should protect marriage.